Okay, let's return to our top story tonight. A judge has thrown out the petition that would have paved the way for a referendum on Alberta separating from Canada. CBC's Tricia Kindleman has been looking into this for us. Tricia, what can you tell us about this decision?
Yeah, so that decision came out today. There was actually two separate decisions that did come out from Justice Shayna Leonard. Now, in that first one, she found that the chief electoral officer had made an error in law, and she said that rendered the chief electoral officer's decision unreasonable, and so that they were not able to approve the second Citizens Initiative petition. Now, it also said that they had failed to consider an earlier decision that said separation would violate treaty rights. So at a presser earlier today, Premier Danielle Smith saying that her government does support Alberta remaining in Canada, but now well over 300,000 people have been denied. She called the ruling incorrect and anti-democratic. The judge found that the government, as a representative of the Crown, failed in its duty to consult with applicants, the Athabascan Chippewa First Nation, the Blood Tribe, the Piikani Nation, and also the Siksika Nation. Now, Smith says that her government will be appealing this decision. She also talked more about that duty to consult. Here's more of what she said this afternoon.
I think that the duty to consult is an obligation on government, specifically when we're talking about the impact on treaty rights over hunting, fishing, trapping, and when we're dealing with particular projects. I think that part of law is very clear. This is pretty murky. That's why we think it may be incorrect and why we have to appeal it, and we'll see if there are other provinces that might be interested in weighing in on this as well.
So now it's worth noting that Stay Free Alberta collected those signatures between January 2nd and May 2nd. That petition was then delivered to Elections Alberta on May 4th. Now, Jeffrey Rath is one of the lawyers working with the group. We're about to hear from him just after this. He posted a statement on social media where he said, "We disagree fundamentally with the decision, which appears on its face to violate principles of natural justice and contain numerous errors of law. We have been instructed to prepare and file the appropriate appellate documents." So next steps seem to be watching for that appeal to be filed. It doesn't mean that separatism conversation is over. There are still calls from some for Smith to just go ahead and to have that referendum anyway. But it is also important to note, as I mentioned, there was that second decision as well. Judge Leonard denied an injunction request from another First Nation to stop the petition. The Sturgeon Lake Cree Nation had argued that the government had violated their treaty rights by making that separatism petition easier. They had lowered the threshold for the numbers, but the judge did deny that injunction request there.
And what, Tricia, you talked a little bit about some reaction there, but what other reaction has there been?
Yeah, well, we did hear from a few of the First Nations. We talked to someone earlier. Our colleagues at Power and Politics also spoke to Chief Alan Adam. He is with the Athabasca Chippewa First Nation. Now, he is calling it a win for Canada, Alberta, and for the democratic process. And he also says that it underscores the importance of treaty rights. Here's what he had to say.
You know, the decisions by the court just confirms everyone that treaty is signed under sovereign protection, and we as First Nations are sovereign people.
Now, he did also go on to encourage Danielle Smith to, quote unquote, take the high road and let's build this country and work together instead of appealing. We also did hear from Opposition Leader Naheed Nenshi today. He said that he supports the court ruling and expressed his gratitude to First Nations communities who filed the legal challenge. Also worth noting that the notwithstanding clause would not apply in this instance. It doesn't apply to the duty to consult. Still, a lot of questions in the air right now, and we'll continue to watch this process unfold in the coming weeks and months, I'm sure, Sarah.
Absolutely. Tricia, thank you very much.
Thank you.
And as you heard Tricia mention there, Jeffrey Rath is a lawyer for Stay Free Alberta, and we are going to hear from him right now. Here he is, joining me now from Foothills, Alberta. Welcome to the program, Jeffrey.
Well, thank you for having me on.
So we kind of know your reaction because Tricia was just reading your post to social media there, and I'm not really surprised by it, that this is not what you were obviously hoping to hear from the court. I'm curious, because you talk about you appealing, and I also understand, you know, the government is going to appeal. So do both parties potentially file an appeal here?
Well, first of all, we expected this decision from the court. I mean, we filed a recusal motion a couple of weeks ago on the grounds of reasonable apprehension of bias. So this decision was completely unsurprising to us. I mean, obviously we're appealing. Obviously the province of Alberta is appealing. This decision effectively makes Alberta ungovernable. If people thought the Cowichan decision was bad, if you really dig into what was done in this decision, it basically means that governments can't govern. I mean, there was no treaty right that was identified as being infringed in the context of this decision. How does putting signatures on a petition and having those signatures counted and transmitted to the legislature infringe anybody's right to hunt? Nobody's right to hunt was infringed during the treaty. Nobody's right to fish or trap was infringed. Even if you take the rights at their broadest, as expressed by the Supreme Court in the Mikisew decision, which I won at the Supreme Court, and that is the broadest right under Treaty 8 is the right to carry on the mode and way of life throughout the tract surrendered as if you never entered into treaty. How do people signing a petition, putting their names on the petition, and transmitting their wishes to their elected officials contravene anybody's right to carry on their mode and way of life throughout the tract surrendered as if they never entered into treaty? So from our perspective, the decision legally is completely incomprehensible. And, obviously we'll be appealing on that basis. I don't think the Court of Appeal is going to have much trouble overturning it.
Right. And so it sounds like you are kind of prepared for that, given that you say you anticipated this. And to your point, we heard the Premier calling this duty to consult in this particular case murky, which is why she says the provincial government intends to also appeal. Can I ask you, we were talking to a First Nations chief just a little earlier about what duty to consult looks like. And it sounds to me like you have given this some thought. It isn't a veto, correct? It is a consultation process.
Right. I've actually won more consultation cases in the courts of Canada than any lawyer in the country, right? So, quite frankly, I was, again, not surprised, that the judge rendered this decision the way that she did, but it's completely outside of the law as anybody knows it. Effectively, she said, and this was in a stay decision that she issued earlier, all you have to do is assert that there is a treaty relationship, not even a specific right, a treaty relationship and a lack of consultation, and that gives rise to irreparable harm, giving rise to, to a stay, preventing government from moving forward. The judge, from our perspective, and this is why we're appealing, has a very weak grip on the law as it applies to First Nations rights in Canada. And, obviously we'll be appealing on that basis.
Okay. So an appeal obviously takes time, probably consultation takes quite a bit of time as well. So where does that leave your movement?
Well, our movement's full steam ahead because, of course, the one thing the justice said in this decision was that if Danielle Smith and the Premier of Alberta, simply on the basis of 301,620 signatures of supporters of the United Conservative Party of Alberta, were to put that question on a referendum ballot under Section 1 of the Referendum Act of Alberta, the court confirmed that would be perfectly legal. So we have this bizarre circumstance where it's not legal if people go out and organize and have 300,000 plus people put their names to a petition, but it's perfectly legal if the Premier does it of her own volition under Section 1 of the Referendum Act, at which point the secession process contemplated by the Supreme Court and the secession reference is engaged, and according to the court, and I think wrongly, that then at that point the court has no further jurisdiction to intervene. We say the court's jurisdiction to intervene would arise after a constitutional conference under Section 35.1 of the Constitution Act, which would require a constitutional conference if there was a devolution of federal powers involving First Nations to the province, right? So there's a legal mechanism for doing that. Something else the judge was wrong about and didn't even mention in her decision.